Hello. Today I have the special honor of interviewing my close friend Peter Verbeke. He was my mentor in university. When I wrote my master thesis, he gave me a lot of assistance, but then he went on to do bigger and better things. Peter was the CEO of Anderlecht and is now the head of PowerPlay. The firm specializes in assisting athletes, and today we'll get an interesting perspective of Peter, who has been both on the club side and on the athlete's side.
Hi, my name is Peter. I studied law a long time ago, graduated in 2005 in Ghent, went on to study another master in law in London. But I started working in football quite early. I think I was 27, 28 when I started working for Club Bruges, where I became head of recruitment. I worked in Bruges for 5-6 years, then was sports manager in Ghent for 2 seasons, and then 5 seasons Anderlecht, where I was sports director and CEO. Since November last year, I started working for PowerPlay, which is a law firm specialized in sports law. And we represent athletes, football players, but also individual athletes. We help clubs, we help agents, and we help everybody who has questions regarding sports law.
Peter, you have the unique perspective of having been both on the club side level as sports director, CEO. Now you assist athletes in your capacity as a lawyer. What surprised you most when you came to the lawyer side of things, so when you started representing athletes and not the interests of the club?
I think when you work for a club, you kind of take it for granted that when the player signs a labor agreement, that he kind of gives away almost all of his image rights to the club, and the club can exploit those image rights. So the club has a marketing department, and the marketing department exploits the image rights or the IP rights both on an individual as on a collective basis. And I must say, in those more than 10 years in football, I never really had any players, any agents complaining about the use of the image rights, the IP rights of the player. I think this is going to change because players are more and more represented by lawyers. And of course, there is the digital age, meaning that you have Generation Z and Alpha who look quite differently towards their own IP image rights than previous generations. So working now for the athletes, for the players, it's different because now you see that, for example, in football, there is a limited space that the player still holds to exploit his own image rights. And it's definitely something that we as a law firm need to protect, even though it's a small space. And of course, for individual athletes that are not football players, for example, the space they have to exploit their IP rights by, for example, signing sponsorship agreements is much bigger. And of course, again, it's up to us, to our law firm, or to law firms like ours, to protect that space.
So Peter, in your daily practice, which side of the IP rights gamma are you most confronted with?
In our daily practice, we don't represent global superstars. There are not so many global superstars that build a brand imperium in sports. We work together with Rock Nation in the UK, who does represent those players, but we don't at the moment. So in our daily practice, most of the IP and image rights questions that we have is how to define these rights, how to structure these rights in, for example, labor agreements between a football player and a club, or in sponsorship agreements between an individual athlete and a sponsor. So this is where we are most confronted with, and I think this is what we have to do, and what we have to do best is protect that space that the individual athlete or the football player still has to exploit his own or her own image right.
Today, athletes have become brands in their own rights. For a young player starting his career, or a young athlete, which assets are often overlooked in an IP landscape? I'm talking about social media rights, image rights, logos, trademarks.
We represent a lot of football players, and as I already explained, in football you have the collective labor agreement, meaning that when a football player signs an agreement, a labor agreement with a club, he basically gives away his image rights to the club. There is a limited space for that player to still exploit his own image rights when it's not connected to the club. And what we often see there is that especially young players are not aware of the fact that, for example, they create a logo, or they shoot photo content, or they shoot video content, and they are not aware that they are not the legal owner of those IP rights. And especially in a young career in the digital era, this is happening a lot. And it's only later on that they realized that they did something that they cannot reverse. So I think it's our duty to make sure that these players don't make those mistakes at an early age, and that they are made aware of their IP rights and how they can start to protect that at a very early age, so in the future they don't get any problems with it.
What we often see in Novagraaf's daily practice is that young startups and even established companies launching new products, new services, often struggle to identify early enough which steps they need to take to protect their IP. Is this something that's true in the sports world as well?
I think it's a very good comparison. I think a young player has to be considered, or should consider himself as a startup, meaning that he wants to build something for himself, a brand that he can commercially exploit. But it's up to us to make him aware that in this startup phase, everything that he does in relation to IP rights is done carefully and the right way. And it's up to us to protect that, so that in the future he doesn't get any issues or problems with that.
Peter, due to the cross-border nature of sports itself, meaning the competition itself can be multiple jurisdictions, you have sponsorship agreements that span sometimes continents. Besides that, is there anything else that makes the IP landscape in the sports world even more complex?
As we have said before, a player or an athlete needs to consider himself or herself as a startup. And it means that we need very good IP, image right protection for the player or the athlete at a very early stage in the career. But we all hope that the player will explode and, of course, play internationally. So it means also that we need to protect the player or the athlete on an international level. And it means that there is a cross-border element to that. So the protection goes further than just the Belgian context, but also where the player or the athlete could be playing in the future. And it's something that we already have to think about today, even if it's not materializing or realizing it today. But there's another complexity, I would say, internationally to IP rights of athletes and players. For example, there's the importance of the federation. As we have, for example, seen in the Nafitiam case, the federation can impose a code of conduct on a player in order to be selected for a world championship or an Olympics. And that code of conduct could be in breach with the own sponsorship agreements of the athlete. And that creates an extra complexity to it, because the athlete does not have a contractual relationship with the federation, but it still has an impact on what he or she is doing. And in football, for example, there's also the FIFA regulations. So FIFA regulations are regulations not only for clubs, but also for players or for agents. And also these regulations play a role on the IP protection of players, for example, or the way that agents work with the players' image rights or IP rights. So that level of international complexity in sports is very obvious.
You have already given us an insight in the complexities regarding IP law between players, athletes, and their clubs, their sponsors, and the international context. How is that relation, or how is that IP question defined in the relation between the athlete and his agent?
It's a good question, because recently we had the question of multiple agents asking us, can we obtain the IP rights of the players that we represent? So basically we pay the player and we get the IP and the image rights and we exploit them and we create the revenue stream for ourselves, not for the player, but for ourselves. The basic principle could be, yes, of course, if the player wants to give away his IP and image rights and he gets paid for that, why not? But the level of complexity is that we also have, for example, FIFA regulations, and the FIFA regulations make it quite clear that an agent always has to act within the interests of his player. So it means that, for example, if an agent is negotiating a labor contract for his player, and at the same time negotiating a contract for himself as regards the IP and the image rights, there could be a conflict of interest, because the more money he gets for the IP rights, the less money the player gets paid for playing football. So that is the first issue that could arise, and the second is the third-party influence on transfers. So FIFA is really clear that Third parties should not have an influence on transfers. And of course, when an agent has the image rights or the IP rights of his player, he can basically block a transfer, which is of course against the FIFA rules. So our advice was that there should be a carve out. So there is a limited space for the player to license his IP or image rights to an agent when they are not connected to the club. So basically the space that the player has for himself to exploit his own image rights or IP rights, that is the space that could get licensed, for example, to an agent. So yes, it's definitely a question that is worth considering, because we get these questions quite a lot.
What are the most common IP disputes or pain points you encounter in your practice, particularly in relation to sponsorship agreements?
I think the main issue is bad contracts. So when a player or an athlete negotiates a contract, he or she is most often very happy. You know, I can sign a deal with Nike, I can sign a deal with Adidas, I get some shoes, I get some clothes, I get some money. But it's very important that every contract is structured in favor of the athlete or of the player, and most often it's not the case. The sponsors, they have good lawyers, but most often the player or the athlete has an agent that is not specialized in law and does not have a lawyer at his or her side. When we look at what's happening in practice, we see that a lot of these contracts are not in favor of the player. For example, exclusivity clauses are not only in relation to competing sponsors, but to whole sectors or even associated brands, which quite limits the space for the athlete to do something else apart from that sponsorship agreement. You have the scope of the sponsorship agreement that is often too broad, or you have the duration that is too long, or you have morality clauses that are too narrow or too broad for the player. So what we need to do as lawyers is make sure that these contracts are drafted in the benefit or in the favor of the player and the athlete, so that he or she basically keeps commercial control outside of that one sponsorship agreement and does not give away too much to that one sponsor. And if this is not done the right way, then you get problems in the future. And this is the problem that we often encounter. And that's why we say, again, even when you're a young player and you sign your first contract with a shoe brand, for example, make sure that you do it the right way. Good example is Michael Jordan. When Michael Jordan signed his, I think his first deal with Nike, it was thanks to the good advice of his mom, not his lawyer, that he signed an amazing deal, and he's still, gaining the benefits of that first deal. I think a lot of players or athletes are not aware of that, and they're too happy to sign, and they sign whatever is in front of them, which is not a good idea.
Digital exposure, especially on social media, has transformed the world we live in. Which challenges should athletes and sports lawyers in this context prepare for?
It's true that players and athletes are on social media all the time. They use Instagram, they use TikTok, they create their own content. So it's definitely something that that needs consideration, because I believe that a lot of these, especially young players and athletes, are not aware of the rights and obligations they have towards the club and towards their own other sponsors, and that they might be doing things on social media that are not in line with those obligations. So I think what we need to do as lawyers is basically make them aware of what they have signed with the club and with other sponsors, so that they don't do stupid things on social media. Of course, also social media experts, not only lawyers, can help them with that. And then the second thing is the content production itself. So they shoot video, they shoot photos, but I don't think many of them are aware that they are not the owner of these materials, because it's the guy or the girl who shoots these pictures and videos that is the owner, except of course when there's an arrangement or an agreement. And again, I think a lot of young athletes and players are not aware of that, and that's where we need to step in and make sure that they don't do any stupid things that might offend clubs or sponsors and get them into legal trouble.
So basically an awareness campaign is really something that is required to ensure that not only they are not in breach of their current agreements that are running with their sponsors, their clubs, but also that they make sure that they obtain the IP rights that are shot by someone else.
Yeah, 100%. This is basically the main thing that we do as lawyers. They sign a contract, whether it's a labor contract or a sponsor contract of 15 pages, but they have no idea what they sign. I'm afraid to say, but a lot of agents do not explain it well to them what they sign. So they need lawyers, and not only to negotiate good contracts, but to make them aware of what they sign. I think this is our most or our biggest duty is basically what you say, make them aware of what they sign and make them aware when we're talking about IP, what is possible and what is not possible based on current agreements that are running.
Peter, the current generation of young athletes has been born into this digital age we're in and has been confronted with social media from a very young age. Does that mean that they're more aware about their image, their reputation, and what it concerns? Do you see any evolutions in that?
For sure. I think recently we even had the example of, I think it was a broadcasting federation and the athletics federation that put out guidelines on how you can film female athletes. Because of course the athletes are aware of the fact that the way they are filmed, the way that the content is produced, it sticks with them for the rest of their lives. So you see that even though athletes give away their IP rights to external parties, they still want to control part of those IP rights and how they are projected, which is entirely logical, like you say, in a digital age where everything sticks with you for the rest of your life. However, I do believe that a lot of athletes are not even realizing enough what the impact could be. For example, in sports, we see a lot of reality TV shows where they, for example, film everything that's happening inside a club. And it's possible, of course, from a commercial angle, that they use one-liners of players or they use footage of players that is not beneficial for the player himself and his future. So I think, again, it's up to us to, first of all, make them aware that everything that is shot or everything that is produced in relation to their IP rights sticks with them for the rest of their lives. But it's our duty as a law firm to cover as much as possible all these situations in the contracts, so that when something is shot where we don't agree with, that at least we can put out the contract and say, listen guys, this is not what we agreed, you cannot do this. If this is not in the contract, you kind of put it on the player to make sure that he doesn't say stupid things, but you know how it goes in daily practice, sometimes you say stupid things. So yeah, we need more legal protection and we need more awareness from the athletes that in this digital age, what's happening with their IP rights is quite significant.
What is the added value of IP firms such as Novagraaf in your daily practice as a sports lawyer?
The core business of a sports law firm is to make sure that the contracts regarding IP rights of players and athletes are structured and well negotiated. But when it concerns about building a brand, the expertise of our firm is limited and we need good partners for that. And Novagraaf, for example, has all the expertise to make sure that, first of all, from a risk perspective, everything is covered. And once the brand has been built, it can be enforced. The benefit of working with a firm like Novagraaf is also that they have international exposure. So it means that whether our sports or our athlete is in Belgium or in another country, they are the right partner to help us with that.
Peter, how is PowerPlay internally structured to handle these complex IP matters?
We see that IP is getting more and more important in our daily sports practice. So we have two people, two young lawyers, Thibaut and Julie, who are not only working on this, but also specialized in this. They did a master in IP law. So it's important for us to have these people on board because we see that these questions are more and more often asked to us. So it's important that we can give all the players that we represent, but also the clubs and the agents that have questions for us, that we can give them the right answers.